35. You have already filed the affidavit.
The affidavit needs to be called by this court to oblige.
Filed out,
35, no, affidavit. Yes.
affidavit filed today, my lord, kindly brought up the court. Item one, my lord, 21, 24 and 34.
1,
1, 21, 24 and 34.
okay.
May prevail. My lord, there is an order passed by my lord, Honorable Justice Suspita Fukan, my lord, to place this matter before appropriate court, my lord. So this is the POXO matter. Your lawsuit is the senior bench taking up the POXO matters, my lord. So may I pray, my lord, this matter may be taken up, my lord, tomorrow, my lord. So this matter was heard yesterday itself, my lord, and CD has been retained, my lord. Because that court is not, my lord, taking up POXO matters. That's why that court has
What
directed.
will be procedure?
If it's mentioned, if it's allowed, then it has to come in code number 24. Code number 24 is taking up the special events.
It has already been mentioned by you.
No, I'm mentioning today, my lord. In fact, matter was heard by my lord Justice Suspita Fukan yesterday. Then she, my lord, directed that it should be listed before the appropriate court, my lord.
Appropriate bench means court number 24 is also taking the special matters. I don't know. That's
Your lawsuit is the senior bench, my lord. That's why I'm mentioning before your lawsuit.
mentioning, I don't know, have you approached the registry?
Not, my lord, because if I approach the registry, then they, my lord, advised me to just approach before the, my lord, appropriate court. So your lawsuit is the, my lord,
It will be fixed. It will be based upon the consent.
Concern for this case number 24, no?
24 is the special.
Special X.
As follows.
lawsuit.
Okay, then
My lord, can it be tomorrow, my lord?
maybe tomorrow.
Deeply obliged.
May I please, Your Lordship. Your Lordship, I beg to mention 2 bail applications for listing tomorrow, Your Lordship. Arising out of the
No,
same
see, I
FIR,
have repeatedly saying that before Bihu, we have some other work. We
Lordship,
don't
can I-
have time.
connected bail petitions are already listed tomorrow, Your Lordship.
No.
Arising out of the same FIR, Your Lordship.
So you are taking that advantage. We are repeatedly saying that we are not in a position to take up the matters. We are saying that this one is disgusting.
May I please, before Lordship. I said before Lordship, regarding item number 2
Hmm.
of this today's list.
Huh?
Of today's list.
Huh.
In this case, on 4th April, it was directed orally, which this is not recorded in the order shown. Wife appearance.
People say.
Depending on compromise purpose bail application. regarding
No,
this.
whatever, if item number 2, what do you want to submit?
My lord, actually, on that day, it was directed to me in this court that a wife must necessary to attend this court for proper execution of the bail application hearing.
Ah.
And she is out of the high court now, yet, my lord. I trying to come.
What timing you want to say?
Yes, no, my lord. Actually, the wife is ready to come here, but he's as directed by your lordship on 4th April. But orders not reflect. For this reason, the security.
She is waiting outside in the High Court.
So what to do? What I can do? What can I do then?
I prayed before lordship.
To ask the security to come her inside. Is it possible?
My lord, actually,
You do whatever you want to do.
my lord,
You want that I should direct the security officer.
my lord, actually, I humbly prayed before lordship
Hmm.
on 4th April regarding the hearing
Hmm.
of bail application for release of bail of her husband. And the wife must be necessary.
No, see,
to
she
attend.
can appear as she was the informant.
Yes,
Most probably that was the reason because she was the informant. So she may come and as an informant, through advocate, she can appear.
yes, my
Through
lord.
she engage any advocate.
Yes, I am the youngest advocate.
So you can appear.
How can you be?
My lord,
You are for the accused also?
no, I am accused only.
You are appearing for the accused? Then how can you appear for the informant also? Is it possible?
On that they order.
No, is it possible?
Not possible, my lord.
You can represent the accused as well as the informant and victim. Now, what are you saying? I don't know. I could not follow you. One hand, you are saying that I have to ask the security to come her inside. On the other hand, you are saying that she is there. You are going to represent both informant and the accused also. Is it possible? What is your professional ethics? Does it permits? As per your professional ethics, is it a? Then how can you?
Depending on compromise letter.
No, whatever, you can engage another counsel. She may appear. I won't say that she cannot appear. She can appear. Informant can appear at any stage. That is there. So she can appear through an engaged counsel or through by whatever you want, through your counsel and someone. Someone can represent her. That is understood.
She can meet PP also.
PP also.
She can meet PP also.
Yes, through PP also.
Send her to office, PP office. She will inform them and they can inform.
My lord, item number 2 may be taken at 2 p.m.
No, that can be. That can be.
Must.
Actually, any.
May I please, Your Lordship? Regarding, I don't know, 27, my lord, earlier CD was called, but CD is not available today.
20?
27.
Yes, they not.
Your petitioner is behind the bar since when? It's a charge
No, no,
sheet
no,
case.
outside of the AB, initiative. AB.
27, sorry,
27.
27.
Yes.
Are you on interim there?
No, no.
You're not on interim. Issue reminder, for 27, call for the CD, issue reminder. And list when it can be listed,
3rd of minute.
3rd of May. 3rd.
6th of minute.
6 will do, 6th of May.
Maybe last week, April last week. April.
He is not in interim, I think.
Yes,
You are not in interim.
yes, madam.
Last to 30, 30, 28. Oh,
Obliged, madam.
Wait, this is a lordship.
28 for.
Lordship, I am seeking your lordship's permission for listing of bail application for hearing on 10th of April, madam.
Sorry.
Lordship, there is a declaration item number 33 for withdrawal, Lordship. Item number 33.
33 for,
33 for withdrawal, Lordship.
you want to withdraw this one
Lordship.
as per instructions of your client.
Lordship. As far as the
Your good name B.
B Borgohai, Lordship.
B Borgohai Kulbade. As per instruction of his client, he wants to withdraw the present petition.
33.
Prayer allowed, accordingly disposed of on withdrawal.
Must be, Lordship. One bail application, regular bail application, on 11th, Lordship, last year.
No, we are not fixing on 11. I may not be available. Just saying that's what I'm saying. You can approach the registry. If a registry can fix the date here and there, then it's okay. You approach the registry,
No,
not
so
before us.
earlier you have.
No, I'm not
They
fixing
allowed,
any
Lordship.
date. No, I'm not fixing any.
For listings, in the last occasion, registry was directed to fix the matter in the appropriate man's lordship.
Hmm. The approach registry, it will be fixed before us.
May I
It may
please-
fix within this before BU also. It may.
May I please, Lordship. Lordship, I beg to mention item number 17 and Lordship 28, Lordship.
Hmm?
It may be taken after Bihu, Lordship.
17 and
17 and 28, Lordship.
one is AB and one is BA.
Lordship.
And the request made by the learning council for the petition. Okay, order how would do that? 27 and 20, sorry, 17 and 28. List after BU vacation. Yes, CD is available. Are you on interim there?
No, Lordship.
You are not on interim. Then you fix the date. He is not in interim. Let it be fixed after Bihu, the last part of April. Maybe,
Last week of April, Lordship,
yes. That can be, I think he is not in interim.
29. Lordship.
At 28, we are fixing it on 29 and other one,
17 is scan copy, Lordship.
17 is scans copy. It's a charge sheeted case, I think.
Yes, Lordship. Yes.
Then 3rd of May, 17 is.
Lordship, will item number 28, CD, I think not received. Received.
Which one, huh?
Yes, yes.
17, received.
3-5 is a holiday, then 1 will. After BU is going to 17 to after BU. At 28 to 29 for Koiriba. You're going to retain the case diary here. CDB retained till next date of listing.
Obliged.
Wait, this is a lordship. Lordship, item number 3 may be taken up along with item number 8, madam.
3 along with 8.
8, madam. I'm okay.
May I please tell one? In this case, my lord, the three persons were arrested. my lord.
You're on item number 3.
No, madam. I am for listing matter, madam.
Hmm.
Three persons were arrested on same footing, madam. One was granted bail on 3/4/2025, and two is remaining, madam. I have filed already, madam.
So
Kindly
whatever you do, approach registry if it can be possible. Then we are now. I'm not going. to.
tomorrow, day after tomorrow.
You can approach registry if registry is possible. Then.
For withdrawal, item 30.
Withdrawal. She's not here. She's not here. List after 1. No one none appeared on call for the petitioner. List after 1. List after 2 weeks after Bihu only. List after Bihu.
Item numbers 3 and 8.
3 who is appearing? Yeah, mate. You are appearing in both 3 and 8.
Yes, ma'am. Petitioners are same, my lord, case is different.
Okay.
Yes. my lord.
Petitioners are same means out of same.
Yes, my lord. Why in item number 3 has been shown arrested, madam.
Item number 3 shown it.
Yes, ma'am. Initially, my lord, he was arrested in connection with special NDPS case number 7 of 2024 on 3/7/24, madam.
3/7.
Yes, ma'am. 3/7/24. My lord, he is not at all named in the FIR. In fact, the lordship takes up the forwarding report, which is at page 18, my lord. 4 persons were named in the FIR, my lord, from whom contrabands were recovered. And I'll just read, my lord, the forwarding report, which is at page 80. May I just read, my lord, 2-3 lines? Yeah. With reference to the above, I would like to inform you that on so and so at about 3 a.m. based on PTL location, we apprehended Usman Ali, that is present petitioner.
No, we are reading which page?
Page 18, madam, annexure 2. Item
So
number,
here pagination is a different, I think. It annexure 3 is the page 18.
it is, item number, lordship is taking item number 8, my lord.
It's 8.
8.
This is 3.
We are taking on 3. We are taking 3.
First, lordship may kindly take up 8, my lord.
Oh, first we are saying
Yes,
8.
yes,
Achha.
ma'am, 8. This is the first case where he was arrested by, ma'am. Item number. That FIR was lost, my lord, on 9/1/2024 because from 4 persons, some contraband weighing commercial quantity was recovered. And this petitioner was arrested on 3/7/2024. Lordship got the got page number 18, yes. My lord, I'll just read the few lines, my lord, from the forwarding. With reference to the above, I would like to inform that on 3/7/24 at about 3 a.m., based on PTL location, we apprehended Usman Ali, District Karimganj. Usman Ali's name have come up multiple times during course of investigation through call details analysis, bank transaction details. We are able to establish link with the accused Nur Muhammad. So, my lord, based on the CDR, my lord, and bank transaction, he was arrested, my lord. Thereafter, my lord, prosecution submitted charge sheet in this case, which is at page, my lord, 19. And they relied upon, my lord, as many as 9 witnesses. 9 witnesses, my lord, to prove their case. Now, my lord, I am placing before the lordship the arrest memo and, my lord, the notice, my lord, which has been issued to me, my lord. And lordship will find there is no mention regarding. Nothing has been seized, my lord, from his possession. He is even not named in the FIR also, my lord. So my humble prayer before lordship is that to consider my bail application, considering the non-compliance of section 50 or 47 of the BLSS, my lord, and I'm a local citizen, person, my lord, residing within the jurisdiction of the special court itself. So I will abide by any condition in the event lordship considers my prayer, my lord, at this stage.
So in this case, he was arrested on 3/7.
Yes, my lord, 3/7, he was arrested.
Now charge has already been framed?
Yes, my lord, charge has already been framed, my lord, and from the e-court, my lord, I have found that it is fixed on. My lord, next month for, I have the copy, my lord, furnished, my lord, the date of evidence. It is fixed for recording of evidence, my lord. I'll provide the date, my lord. I have the copy. Oh, this is it. It is, my lord, fixed on 19/4 for evidence, 19/4/2025 for evidence, my lord. Now, my lord, I'm placing the matters relating to part item number 3, my lord. In this case, my lord, this is the in this case also, my lord, he is shown arrested on 5/9/2024. I'll take my lords to page number 16. Here in this case, my lord, only one accused person was there from whom contraventions were recovered. This petitioner was not even named, my lord. And page 16, I'm paying your lordship for perusal, my lord. May I just read, my lord, that order? Page 16, my lord. IO has appeared and submitted a petition for showing arrest of the accused, namely Usman Ali, who is in jail custody in connection with special case number 7/2024. Issue production arrest, intimate jail authority accordingly, as today fixed for production of Zakir Hussain. So later on, Malad Usman Ali was also produced, Malad, and he was given police custody for 1 day. And then, Malad, page 18. 18 is the annexer 3, Malad. Then on 6/9, he has been forwarded, Malad, to judicial custody. May I just read, Madam, that with reference to the subject cited above, I have the honor to report that in connection with the above cited case reference below noted accused was shown arrested on 5/9/24 and the Honorable Court of Additional Session Judge Karimganj on the same day allowed 1 day police remand of arrest of accused person. Now, after completion of police remand, I am producing arrested accused person before your honor with a prayer to keep him in judicial custody. Now, Malad, I'll place the certified copy of order dated 6/9 when he was produced along with his forwarding report, Malad, to show some what are the documents Malad faced during production. May I just read, Malad? 6/9, Malad. Accused Usman Ali is produced before me from police custody on expiry of police remand allowed by order dated 5/9/24. Seen the connected documents, including forwarding letter, which I have already annexed, Malad, page 18. Accused challan, medical report, interrogation chart, inspection memo. So these were the documents, Malad, which has been placed before the special court, Malad, while he was forwarded. So there is no, Malad, 47 notice or any other document intimating him the grounds of arrest, Malad, which is also Malad, mandatory in case of shown arrest also, Malad. Malad, the records I have with me, Malad, that interrogation chart and other things. Inspection memo, accused challan.
Yes, do you have any other authority in this regard?
My lord, authority. My lord, one Mufaddal Islam I am having, my lord, just the file I have kept, but I'm giving you, my lord, one authority of our honorable court, my lord. That
Coordinate bench?
yes, coordinate.
That I have.
Yes, my lord. That, in shown arrest also, my lord, the requirement of section 47 is mandatory, my lord. I'll just hand over, my lord. Giving you.
Sure, what is happening that shown arrest, the accused, the CD generally produced before the court.
Yes, my lord.
And on the basis of the materials collected by the IO so far,
Yes.
the prayer for shown arrest generally allows.
Yes.
The scope of this, the issuing notice of 47, 48, obviously, reasons has to be provided to him as why he is in shown arrest in this case. That is there. Principle obviously there.
Yes.
But procedure is following in that manner only. That's why most probably, though there is a challan or medical documents are available,
Inspection memos are.
inspection memos are, but 47 is not available. That
Then otherwise, my lord, law requires that it has to be followed, my lord, because procedure laid down in shown arrest and arrest is similar, my lord. There is no such differentiation between the two, my lord. But I'll hand over the coordinate bench judgment, my lord.
no, that we have already.
Yes. So, my lord, my humble prayer, my lord, I'm a local person, my lord. I'll face the trial. In this case also.
Yes, Your Honor.
It is fixed on evidence 6.
You will also in item number.
It would that.
Eight Lokship is already, it is clear Lokship, the grounds of arrest may not be there. But in three Lokship has pointed out, they're quite different in shown arrested case. So Lokship, if Lokship wants to verify, then we'll have to call for the records because CD already charged it. That is the only difficulty. At this stage, it cannot be said clearly that 47 has not been complied with.
Order request 6/9/24 itself clarifies that aspect, my lord. All the documents which has been produced by the court IO, my lord, has been recorded by the honorable special court, and that also I have produced, my lord, and given a copy to my lord, senior colleague. I have also placed the certified copy before, my lord.
In the forwarding report that is on page 18,
Yes, my lord.
there is no mention about the documents which were annexed along with the forwarding. It's not there.
It's not there, my lord. It's good.
Yes, but in a position, we are not in a position to say anything most probably. In regards to 3, I'm only 3. If there was any compliance, we don't know at this stage.
So in the order also it is stated, keep the same with CR, case record.
These documents.
Yes, this document. So in the case record, we do not know whether.
Copies were furnished to us, my lord. This because charges already been paid, so copies were furnished to us. And I have requested, my lord, yesterday also, last week also, to the trial conducting council. They have also, my lord, gone through the court records to find out whether as to there any notice, my lord, and they have also intimated, my lord, they could not find.
Dictation যোৱাকালি আপুনি লোৱা নাই ন? এই কজ শোকজৰ শোকজ নহয় shown arrest ৰ dictation আপুনি লৈছিলে shown arrest ৰ dictation এটা কালি লৈছিলে কোনে লৈছিলে পাহৰিলোঁ মই। It was
আৰু copy
dictation to have these 2 items. তো সব নম্বর লগত আছে ইটো আপুনি ল'ব পাৰে 8 to 8 is different. Heard Mr. M.A. Chaudhary, the learned counsel for the petitioner. It is 8, huh? Petitioner, and also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. This is an application, the section so and so in connection with so and so. It is submitted by Mr. Chaudhary that the accused was arrested in connection with this case on 3/7/2024. And since then, he is in custody. charge sheet has already been filed. And no witnesses, charge sheet has already been filed and charge is also framed against the present petitioner. However, till full stop, however, till date, no witnesses would be examined by the prosecution, though 9 numbers of witnesses are shown in the charge sheet. Further, he submitted that nothing has been recovered from the person of the present accused petitioner, and he is no way connected in the alleged offense. Next para, Mr. Chaudhary further submitted that at the time of his arrest, no grounds of arrest was been mentioned, neither in the arrest memo nor in the notice issued against him under section 47 BNSS. বাকিখিনি আমি পিছত কৰি দিব তাৰপৰা same order হ'ব. Next para, Mr. Sharma, the learned additional PP submitted in this regard that considering the materials available in the case diary, the charge sheet was filed against the present petitioner and the case relates to commercial quantity. The further submitted that charge has already been framed and case is fit for evidence. Accordingly, he raised objection and submitted that the prayer for the petitioner should not be considered at this stage. বাকিখিনি আপনি 40, 37, 37 যিবিলাক আছে তাৰ লগত মিলাই দিম। Okay, we'll pass the order. Okay, বাকিখিনি, this is for 8. 5 to 8 to the end of the order. 3 2 will be with 3 will be with Shabna. Okay.
May I please, Your Lordship?
We were calling for, in fact. 32 after Bihu Koi disil na. So cut off. You want to withdraw this one
Yes, Lordship.
as per instructions of your client.
Yeah.
What is your good name?
Anjad Azad.
Anjad Azad. Your name is not reflected.
On behalf of AMD.
Anjad Azad appearing on behalf of MSA meeting. If you withdraw Koro besides the instruction of the client. Okay, your prayer is allowed. It has been withdrawn.
I can post.
This was good.
May it please, Lord. Lordship, may I have a look at page, my lord, 18, my lord.
Page 18.
18, 1-8, my lord. The relevant is at page 19, my lord. Third paragraph, my lord. Mr. Borua learned additional public prosecutor submits, though the case was listed today for production of the case diary before this court, but the IO has already filed charge sheet in this case, by charge sheet number so and so. In this context, Mr. Ahmed, learned counsel of the petitioner, submits the petitioner is behind the bar since 29/1/25. Hence, he prays to grant the bail, my lord. Next paragraph, my lord. Considering the submission of the learned counsel for both the side and considering the facts of the case has already been charge sheeted by charge sheet number so and so, it is provided that the petitioner shall file a petition for grant of regular bail and the learned court shall below consider the same in accordance with the law. Now, your lordship will turn to page 22 for a once. When I approach the court below, my lord, the SDGM S. Baksa, my lord. This is the order dated 29/3/25. Case record is put up on stand, bail petition number so and so, my lord, filed by so and so. Hard perused. The learned APP had submitted that the investigation is not yet over. Releasing the accused person at this stage may jeopardize the investigation. Charge sheet was not there, my lord.
Oh.
And my lord, this order was passed on 29/3/25. Lordship, may kindly note the order date, my lord.
Yes, 29/3.
29/3, my lord. And I was forwarded, my lord. I was forwarded on 29/01/25 at page 16, my lord.
You are forwarded on 29.
29/01/25.
Oh.
To my calculation, my lord. On
So
the date,
29/01/25 only you were forwarded.
yes, my lord. And my lord,
Very wrong thing is
yes,
there.
my lord. And 29/3/25, the court below had passed this order, rejected my bail application. And to my calculation, my lord, 60 days will be on 29/3/25.
It's a 60 days of.
60 days offense, my lord. Your lordship will see the offense, my lord. First page, my lord, cost title, my lord, 3032, my lord, 5 years, 318 within bracket 4, my lord, it is 7 years, and 111(2) and 111(4), my lord, these were subsequently added. Those are also 5 years, my lord.
Why this information with us? It was given that this charge sheet was filed and we this charge sheet number was also given to us dated. Yeah, obviously it was dated 22/3/2025. Why charge sheet was not put up before court, or what is the position? I don't know.
We searched.
Maybe it is in the office, I think.
No, we have gone to the PI office also. It's not there, madam.
But that information was received by the
Yes,
learned
madam.
AP from the concerned IO only.
Yes,
And the charge sheet number was also there.
yes. Not paying just now, madam. Let my friend have a contact over the phone with the present police station.
No, otherwise also you were in custody, then I.
60 days, today is 70 days, madam. Before, let him take the instruction at 2 will.
Instruction,
To
why?
be fair enough,
These things
madam.
are happening because 29/3 the order was
Yes,
passed.
yes.
Then
On that day, madam, it will be 60 days. And even
on
one-
29/3.
even 1 day is excluded, madam, then it will be 59 days. 1 day is excluded, madam.
Even if 1 day.
Yes, madam. Then it will be 59 days, madam. Let him take the instruction at 2, madam.
Okay.
I'm fair, madam. Otherwise, I could have argued, madam. Let him take the instruction whether investigation was on or not.
Because on 25, 20, sorry, the order was passed on which date? Our order
29, our order, my lord, it was
28.
passed
28.
28,
28/3.
and the next day we approached them.
Probability is that on that day, most probably it was not put up before the court below. That
Eh,
may be one of the aspects.
Yes, but we have inquired with the PI office also. It was also not there.
Okay then. That too.
Item 5.
May I please, your lordship.
Yes.
Lordship may kindly come to election number 6, lordship. Page number 34.
30?
34.
Hmm.
Lordship, this is again a blatant disregard of the law laid down by the Honorable Supreme Court as well as our own court. There is nothing written down in the notice to the arrestee, whether it is under 47 BNSS or under 50 CRPC.
That
nothing
is also
there.
not there.
Nothing is there. And in this ground itself, Lordship was pleased to allow the co-accused to be granted on the bail. This is the ground on which the co-accused has been granted on bail, and I should be very fair in saying that here charge sheet has already been laid. Charge sheet has already been laid, and we had filed one discharge petition, and there was hearing on the discharge petition, and on 11th, the order is going to be given. The discharge petition was on the ground, lordship, that nothing was recovered from her conscious possession. Because the contraband that was recovered, although I am not on merit now, the contraband that was recovered from the booty of the car. And she was traveling in the co-passengers. She was traveling in the co-passenger seat. And the accused whom your lordship has granted bail was driving the vehicle. Was driving the vehicle. And your lordship has granted the bail purely on the ground of non-compliance of 50 and section 47. Lordship, may kindly come to paragraph number 7. May I read it, lordship? Mr. Halloy further raises the issue that at the time of issuing the arrest memo as well as the notice under section 50 CRPC corresponding to section 47 BNS, no ground was been mentioned which is mandatorily required, and in absence of the ground of arrest, it is in violation of Article 21 and 22(1) of the Constitution of India. He further submitted that the accused petitioner was arrested on 17/8/2024.
Your petitioner was arrested on?
17/8, same date, and was remanded for judicial custody, but due to non-mention of the grounds of arrest in the arrest memo as well as in the notice of section 50 CRPC, lordship may kindly see, this is the notice arrest memo. I would like to show one more thing in the arrest memo, how things are working. Lordship may kindly see, I'm sorry I could not annex it. Here in the arrest memo, lordship, the legislature intent two things, Lordship. Number one, that friends and relatives should know that the person is under arrest. Here, no signature of any friends and relatives has been taken.
No, 48 was issued, I think.
No, 48 was not issued, Lordship. Annexure 6, if your Lordship looks into, that is the notice of arrest.
The notice of arrest to under 47 or whatever, or 50, but whether the family members were also informed through any notice?
No, none was informed. And Lordship, we may say that since the co-accused has been arrested, from the co-accused, they came to know that she has been arrested in connection with this case. Otherwise, it would have been a case of habeas corpus. Because Lordship, see the arrest memo, what is the necessity of giving the arrest memo? And in that very necessity, the legislator intent is that the friends and relatives should know that arrest has been done. And there is a specific column for that. Lordship has kindly seen. So now I continue with my reading of the judgment, Lordship. Arrest memo as well as the notice under section 50 CRPC corresponding to section 47 BNSS. The arrest and the remand itself is illegal. He accordingly submitted that all the particulars of the offense which is alleged to have been committed by the accused should be informed to him at the time of his arrest, and otherwise it would be against the mandate of the Constitution of India as well as the statutory provision which would vitiate the arrest itself. Now, Lordship may kindly come to 9. I am also relying upon these two judgments, Lordship, the Vihan Kumar versus State of Haryana and Prabir Purkasa versus State of NCT. Apart from that, I have got one of the recent most judgment to show to your Lordship that was pronounced on 25th of March 2020. 25th. This is Ashish Kakar of versus UT of Chandigarh. Here also, Lordship, the same thing has happened.
I have, I think.
Ashish Kakar, I think Lordship has
Yes,
already gone through. It was same thing they have to say. We are in agreement with the submission made by the learned senior counsel appearing for the appeal under the said arrest memo cannot be constituted as a ground of arrest as no other worthwhile particulars have been furnished to him. So
Ashish Kakkar versus what is this?
Ashish Kakar versus State of UT of Chandigarh. Your Lordship wants to, I can just hand over this for a
I had, I think, but I don't know whether it is.
citation is here, Lordship, if your Lordship.
Just tell us the citation.
2025 Live Law SC 367.
Okay.
Now, Lordship may kindly come to 9, paragraph number 9. He further submits that though in the case of the commercial quantity, the rigor of section 37 NDPS Act follows, but in cases where there is a violation of the constitutional provision as mandated under Article 21 and 22 of the Constitution, the statutory restrictions will not affect the power of the court to grant bail in such circumstances. More so, non-mentioning of the ground of the arrest while issuing the arrest memo or notice under section 50 CRPC corresponding to section 47 BNS is itself a violation of Article 22(1) of the Constitution of India. And hence, without even going to the detail of the merit of the case, the petitioner, the present petitioner is entitled to bail. Now, this is the judgment of this honorable court. So, Lordship may kindly see, I am praying for the same parity. Nothing more than that, Lordship.
Yes, Sharma.
Actually, the records are not before us, Lordship. That is the only reason.
This is the judgment. This honorable court itself. Mr. Sharma, we can give it. Madam, is still fighting.
Apne mari go. Whatever on this it will hobo judgment. It line out is abo.
To belik case na.
এটা খালি আশিস কাকার এটা আছিলে আছে no we had did this one only it was supplied in print এতিয়া চন্দ্ৰমলকটা আছে না এইটা আছে না we had আর নহলে আপনি কোনাই দিব
We can provide a copy to your Lordship regarding Ashish Kakar. We can provide a copy to Ashish Kakar. But you are
Ashish
praying for the
Kakkar, you are
same.
relying on para which one?
This is Lordship. Para wise, it's not given, Lordship. Here it is,
Page
it should
number.
be from the last, third paragraph, Lordship. From the last, the third paragraph.
Okay.
So I'm praying for the same parity, Lordship, because co-accused has already been enlarged on bail, Lordship. On the principles of law as that has been laid down in Vihan's case, Lordship.
Heard Mr. A.K. Bhattacharya, the learned counsel for
A.
the
Bhattacharya Lord.
sorry, A. Bhattacharya. Today, court number 1 is, I think, busy with some. Court number 1,
Lordship.
two petitions are there, I think, in court number 1. Anyway, heard Mr. A. Bhattacharya, the learned counsel for the petitioner. And also heard Mr. B. Sharma, the learned additional BP, appearing on behalf of state respondent. Okay, this is an application under section so same over. It is submitted by Mr. Bhattacharya that the present accused petitioner is innocent and she is no way connected. She's a lady, na?
She is a lady,
She's no way connected. to
having
the
two
arrest.
minors on Lordship.
She was a passenger in the state
Co-passenger.
vehicle, co-passenger in the state vehicle from where the contraband was alleged to have been recovered. And also she was not aware initially she was also not aware under which case she was being forwarded by police. She's also behind the bar since
Since 17/8/2024 Lordship.
and she got arrested in connection with this case.
The
on
234 days Lordship.
17/8/2024, and since then she is in custody. Bakikini more or less time hobo, same hobo. Only one argument is also placed by the so that the notice which was issued to the present petitioner, the grounds of arrest was not mentioned in the notice issued to the present petitioner. More particularly, the section under which the notice was issued is also not mentioned in the notice. In the same time, in the arrest memo also, no grounds of arrest has been mentioned. In the same time, it was not informed to her relative or friend as required. And there is no signature of any relative or friend of the present petitioner. Otherwise, more or less same takibo. With Bihan Kumar Logot, give one more citation. One more citation along with Bihan Kumar Diva. The Ashish Kakkar versus State of UT of Chandigarh, 2025, Live Law SC 367. Is a submission for a lot. If add this one also. The rest will be same. Mr. Halle, so far I can remember, he was also submitting one thing, that as per the contraband which was seized is a green leafy substance.
Leafy substance.
So without the
Absolutely.
fruiting top and this
Absolutely.
one, that it won't come or it doesn't come under
Come
the
under-
NDPS. That was his
Absolutely.
service. That can be recorded by from your side also?
Yes, Lord.
Okay, it will be disposed of.
Diploblast Lordship.
Same order. Yeah. Hello, come on, go finish it.
Item 6.
May I plead your lordship? This is a bail application under section 483 of BNSF lordship. Lordship, the petitioner has preferred a criminal petition before this honorable court, and accordingly on 21/3/2025 lordship, page number 44, this honorable court has passed an order. Whereby this honorable court has stayed the execution of NBW lordship against the petitioner lordship, and accordingly on 27th of 2025 lordship,
27?
3 March 25 appear before the honorable session judge Lakhimpur, and accordingly he prayed for regular bail lordship, and the honorable session judge has rejected the same lordship. And this is page number 46 lordship, annexer G. And petitioner is not
40?
behind under the judicial custody lordship.
Where is the order? 40.
46 lordship, page number, operating price 46.
Your petitioner's name is
Samir Puri, Lordship.
Samir Puri.
Lordship, all subsequent orders are annexed from page number 20, Lordship. Lordship, there have no delay from the part of the petitioner, Lordship. When he was absent, the same day, Lordship, PW are also absent, Lordship.
Yes. Sharma.
Only observation the court below has given lordship that there is a possibility that he will default again. That is at page 46. Page 45, last paragraph, lordship will see paragraph number 7. Records reveal accused past conduct is not regular. 3, 4, 5, 6, 7
That
days.
is the view of the court.
Yes.
He may again.
Yes, it is the view. Lordship.
Lordship, but PWs are also absent. Therefore, no delay on the part of the petitioner, Lordship. Lordship, on last occasion, he was absent due to his illness, Lordship, and I annexed the medical prescription on page number 37 and 38, Lordship.
Sharma, can you confirm the order he surrendered before the Nane trial court below on
Yes.
27/3?
Lordship may give the direction that in future he will not remain absent lordship without representation.
So since 27/3, you are in custody now. You are MS?
At Alugdal.
Huh?
At Alugdal.
8 Talukdar. Or Mr. 8 Talukdar, the Nane counsel for the petition. Your name is not reflected, in fact.
But I signed the Wakalatnama.
Oh, so MS is not there anyway. 8 Talukdar, the Nane counsel for the petitioner. And also heard Mr. B. Sharma, the Nane additional PP, appearing on behalf of state respondent. This is an application in section so and so in connection with so and so. Next, it is submitted by Mr. Talukdar that the accused petitioner was earlier defaulted in 2-3 occasions, one for which the NDW was issued against him, and accordingly he approached this court with a criminal petition number 384/2025, whereby wherein by order dated 21/3/2025, the present accused petitioner was directed to surrender appear before the Nane trial court below on or before 27/3/2025. And in pursuant to that order, the accused petitioner appeared before the Nane trial court below and surrendered himself, but considering his earlier conduct, his petition for bail was rejected by the learned session judge, Lakhimpur, not Lakhimpur, wide order dated 27/3/2025, and since then he is in custody. She further submitted that he will regularly appear before the learned trial court below as and when the date to be fixed by the court, and will face the trial if he is allowed to go on bail. More so, being a local person, there is no chance of absconding. Rather, he will extend his, rather he will appear before the court as and when. Then there is no chance of absconding. He had to remain absent from the court only due to his medical grounds, but presently and presently he will appear before the learned trial court below and face the trial and will face the trial. Next para, Mr. Sharma, the learned edition PP submitted in this report that considering the the other aspects of the case, he may be given a chance to contest the case. He may be given a chance to maybe allowed to go on bail, maybe allowed to go on bail with some strict conditions. Next para, hearing this submission made by the learned counsel for both sides. Considering the order passed by this court dated 21/3/2025 in criminal petition number criminal petition number 38/2025. No, submission so it is seen that hearing submission so it is seen that as per direction of this court dated 21/3/2025 in criminal petition number 384/2025, the accused petitioner had already appeared before the trial court below with a petition for regular bail. However, the same was rejected, considering with an observation that the accused may again default in the case, which may delay the disposal of the same. However, considering the subsequent conduct of the accused petitioner, who appeared surrendered before the learned trial court below, complying the order of this court, I find that the order of this court vis-a-vis also considering the fact that he is in custody since last 27/3/2025. I further find that further custodial detention may not be required in this case. I accordingly take bail to the report to the satisfaction of Session Judge Lakhimpur, North Lakhimpur, with a strict direction to appear before the learned court below on each and every day to be fixed by the court. Yes. Yes. Inside. নহলে নালাগে ইনসাইড ডিফাইন কৰিব মোৰ টেবুলত দি থোৱা যায়।
This is the search-seated case, my lordship. And here, the summons has been issued against the accused petitioner, but at the time of the investigation, the petitioner were not on bail, my lordship. And the search sheet has been submitted under the non-bailable sections, and it is a session triable. And this case is pending before the judicial magistrate first class. And so far, this is the case of session triable, and the petitioner apprehended that at the time of appearance, he may be arrested. And on this ground, the petitioner has appeared for his honorable court and pray for pre-arrest bail, my lordship. And at the investigation stage, also the notice was issued against the petitioners to appear before the investigation officer, and they has already been appeared, and they are not arrested. And now at the time of filing of search sheet, new section has been inserted. This is 123 BNS. This is the session triable. And my humble submission, the petitioners are ready to face the trial. The direction may be given to it.
So you have not quoted this section 123?
Yes, I quoted.
Your post title.
This is I have quoted the PS case section of the PS case at the time of registered of the PS case 1172 was there, but at the time of the submitting the search sheet 123 section has been added. I said search sheet has already been available here. I have annexed the search sheet, and this is the kindly have a look the page number 12. Case number 21 is the search sheet, Lordship. And point number 3, section 123, 35, 296, 329, subsection 3 BNS. Section has been inserted, my lordship.
That should have been mentioned also in the course.
Yes, but so
Not been mentioned in it.
my humble submission, the petitioner may be directed to appear before the trial court. In the meantime, his petition may be considered.
Yes, Sharma. You can be directed. It's not here.
P. Thakuria.
B Kaplan.
P. Thakuria.
P.
P. Thakuria.
P. Hi, Mr. P. Thakuria, the London Council for the Petition, and also hi, Mr. P. Sharma, the London Edition PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Thakuria that the accused petitioner was not aware about the pendency of this case, nor he was aware about the filing of the lodging of the FIR and lodging of the FIR. Also, he was never searched by police at the time of investigation, and he came to know about the pendency of this case only when you have received the summon.
Yes, someone. I have this.
Have you annexed the order in it?
I have annexed the order. Yes, someone was issued on. Have a look, the page number 30. This is the order 16/12/2024. After taking cognizance, a summon has been issued to the petitioners.
Next date is 24/4.
Yes.
Your petitioner's name is Usman Ali.
Yes, no.
No, sorry. Your
Dalimi
petitioner's
Kolita.
name is Dalimi Kolita, no?
Yes. And two accused are there, Dalimi Kolita and Korisma Kolita.
It was hearing to who is it? It is already given, I think.
It's given. Sure.
Sure. Is it that's all? Only after receiving the notice, summon in connection with PRC case number 314 of 2024 from the London Trial Court below. The summons were issued after framing, after taking cognizance under section 123/3 subsection 5, 296, 329 subsection 3 of BNS. However, the steps were also already taken on behalf of the present petitioner. Petitioners and Dudas. Petitioners. The accused petitioners are ready and willing to cooperate. They're ready and willing to appear before the London Trial Court below and to contest the case if they are provided with some interim protection. Post. If further submitted that initially the case was registered under section 117 of the subsection 2, 3 subsection 5, 296 and 329 subsection 3 of BNS, but the charge sheet was filed under section 123/3 subsection 5, 296, 329 subsection 3 of BNS, which is Sessions Tribal, and hence present petition has been filed seeking the pre-arrest bail for the present petitioners. Next para, Mr. Sharma, the Land Edition PP submitted in this regard that the petitioners may be given one chance and may be directed. No, petitioners may be directed to appear before the London Trial Court below with a regular application of bail, which may be considered in accordance with. Next para. Hearing this submission made by learned counsel for both sides and on perusal of the case record, it is seen that the present accused petitioners were shown as an absconder in the charge sheet, and the summonses have already been issued to the present petitioners. Full stop. However, the petition filed on behalf of the on behalf of the petitioners were also considered by the learned trial court below. Learned trial court below. Next, full stop. Next date of appearance for appearances fixed on 24/4/2025. 25. Next para. Considering all the aspects of the case, I find that I don't find them alleged. These two petitioners are hereby directed to appear before the learned trial court below with a regular application for bail, which may be considered in accordance with law. However, till their appearance till 24/4/2025, the petitioners may be provided with an imprint protection, and in pursuant to that, no coercive action shall be taken against the present petitioners. List. Masuk.
Finding one.
In this case, my lord, I have been in custody since long now. And now, my lord, today I have filed additional affidavit in respect of the arrest procedure. And this additional affidavit, my lord, is in record, my lord.
So you have annexed the notice 50
Yes.
TRPC?
Yes, my lord. And next page 58, my lord. Page 58. 59 is the arrest memo and 60 is the inspection memo. No ground is mentioned. The been in custody since 4/12/2023. This trial is going on, maximum punishment is 3 years now. Almost 1.5 years have been elapsed.
Otherwise, trial is going on.
Trial is going on. And otherwise, my lord, the victim and the informant is examined already. I have annexed. The
Victim examined.
Victim and the informant,
Informant.
both are examined. I have annexed with the petition.
You have annexed this one?
Yes. Ma'am. I have annexed the petition. Page 34 in the petition, the victim. And page 36, the informant. And your lordship directions that earlier that you come again after examining the victims.
Earlier.
This I have annexed also. Page 33, my lord.
Yes, sure. Okay then. Now they are with the other two grounds. Right.
Already examined.
Heard Mr. H.R. Chaudhary, the learned counsel for the petition, and also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Steps have already been taken to the respond number 2, but till that, it has not been returned. Next photo, it is submitted by Mr. Chaudhary that the present accused petitioner is behind the bar. Since when it was arrested?
4/12/2023.
4/12.
4/12/2023.
4/12/2023, and since then he is in custody. But he submitted that his earlier bail petition was rejected. Therefore, bail was rejected with an observation that till the completion of completion till the recording of it on evidence of victim and the informant, the bail No, no, like his earlier bail petition was rejected with an observation that uh, without recording of the evidence of the victim and the informant, the bail may not be considered. But presently, both the victim as well as the informant are already been examined in this case. Full stop. If further submitted that next paragraph that we also arrest taken life. From a submission for that submission for বিশেষ নাই considering the nature of offense, the petition may not be considered at this stage. It was submission কৰিলে হ'ব বেলেগ নালাগে. To whose satisfaction this one?
My lord, it is special just before the learning session just Karimganj, Sribhumi.
Session means special.
Special judge.
Special just
But in
Sribhumi.
pending at session just Sribhumi.
Whatever, it will be considered as a special judge. Special just Sribhumi.
Sribhumi.
For bail hearing, item 9.
And the pass over the therefore time being urged.
Where your senior is that? In court number? Huh?
17 lodge. 17.
So minimum, I mean, before 1 he can appear or otherwise
Lordship
she
may
is
take up-
waiting.
Lordship take up at 2 lordship. Otherwise, I have to engage here
Okay, then at 2.
at 2.
Okay. Ask your senior, Mr. Kyle
This
to
is-
appear on 2.
Accused is inside the jail for about 4 years, 6 months, and co-accused got bail from the Honorable Apex Court lodge.
Okay, you bring all this
Lodge. Oh, lodge.
at 2 p.m. huh?
Lodge.
Item 10.
Wait, this is the lordship. Lordship, items 10 and 14 are connected matters, madam.
10 and 14.
14. Two petitioners, madam, they are accused in citizen. City and case that is same. Yes. Wait, this is the lordship.
It is out of same FIR.
Yes, madam,
Acha.
same.
Yes.
My lord, in this case, FIR is that my lord, prosecution stopped one 6-wheeler truck, my lord. Now that truck is run and operated by one logistics company, namely ATC Supply Chain. From there, my lord, they have recovered some contrabands of codeine based phosphate, my lord, and they arrested the driver. Now, my lord will kindly peruse page number 13, my lord, FIR, my lord. I'll just show your lordship the name of the apprehended accused person. Now, he is the driver of ATC Supply Chain. Vehicle also belongs to them, my lord. That is there, my lord, FIR itself. Lordship has got it, my lord, 13. Page, yes. Ravindra Singh. Yes.
Your petitioner in item number 10 is a driver.
No, my lord, I am not representing him. My learned brother is representing my lord.
I mean,
50.
No, you are saying that item number 10 and 14 are out of same FIR.
Yes, sir. 15 is also my lord, same.
No, okay, then whatever. Now 10 was the driver. No.
No. He's my lord. He works in another logistics company, namely SB Logistics. He is not at all involved in this case, my lord. Although he has been arrested and forwarded to judicial custody on 16/2/2024, my lord.
He is a employee of SB Logistics.
Yes, my lord. Another logistics company that has no relation with ATC Supply Chain.
ATC?
Supply chain, my lord. The contraband substance alleged to be recovered from a logistics company, namely ATC Supply Chain. I am not the employee, my lord. That has been stated in the charge sheet itself, my lord. And thereafter, my lord, lordship will turn to page 16, my lord. 16, lordship has got it, my lord. There is the forwarding accused challan, my lord. Petitioner serial number 4 is Ranjit Karmakar. And serial number 3 is Dhirendra Rawat, that is petitioner of item number 15. So they are the employee of logistics company, my lord. For no reason they have been, my lord, arrested, and thereafter, my lord, the prosecution on 37/2024 laid charge sheet against the present petitioners along with others, my lord. 4 persons were arrested, my lord, driver, these 2 petitioners, and 1 person, my lord, absconder accused, Vidhan Roy. It is at page 19.
Absconder is?
Vidhan Roy, page 19, my lord. Page 19 of the charge sheet. My primary ground for pressing my bail application that, my lord, when I was arrested, my lord, I'll just, these records are also there, and I have also obtained the certified copies, my lord.
As to I have checked my already.
Nothing is there, my lord.
Like my full sign. Can copy the card. Like full sign. Thank you.
There are certificate copies of that arrest memo.
Yes. That is also in the records, my lord.
Both Ranjit Karmakar and Dhirendra.
Dhirendra, yes, my lord.
Basically, that lot ground of arrest. Main plea at this place. I don't know.
Yes.
So you are in custody since when?
My lord, 15/2/2024.
And what is the stage of the case at present?
My lord, I have checked, my lord, from the e-court. It is fixed for framing of charges on 9/4/2025.
It was delayed because of one absconder.
One absconder.
It's same both Dhirendra and Dhirendra is also working in SB Logistics. or
Yes,
like-
madam. Dhirendra is also working in SB Logistics. Both are that part Lordship will find in the charge sheet itself, madam. I'll just request your Lordship to. Yes. Page 32, madam. Page 32 of the charge sheet. Item number 10. Lordship has got it that written in bold manner. May I just read manner that part that will clarify manner. From the statement of witness, it appears that the unknown person within the Sapon Das in collusion to Vidhan Roy running a narcotics racket from Assam to Agartala, Tripura. Further to be noted that as per the order of Honorable SP Sir, along with staff proceeded to Guwahati Kamrup Metro on 12/2/24 and arrived on 13/2 and began our investigation. During investigation, it came to know from ATC Supply Chain Private Limited Beltola that one unknown person driver has bought the consignment containing 67 cartons of papad along with papad chalan. After verifying the chalan copy of the papad, it came to know that the chalan copy was manipulated by making duplicate using the GSTN of another enterprise, that is the name of Vishal Enterprise located at the Fancy Bazaar, Guwahati. During further investigation, unknown driver was found and interrogated him. The name of unknown driver, Padum Rava, who works as a driver under ATC company since from many years. Padum Rava revealed the unknown person who hired his vehicle for transportation of 67 cartons to ATC's office from SB Logistics old godown located near Boragaon area. Through the contact number of the unknown papad supplier, both were trapped along with the helper Deepak Gurung from Boragaon area and interrogated them. From their interrogation, it came to know that the papad cartons were loaded from SB Logistics old godown. The godown in charge, Dhirendra Rawat of
So that is the link. Your papad was loaded from your SB Logistics.
Yes, they said that, my lord, one unknown person received papad packets from SB Logistics. Then they booked it to the ATC supply chain. Man. In between, my lord, that unknown person has also, my lord, done some mischief, my lord. So my police went to our office and finding Ranjit Karmakar and Dhirendra, they took us, my lord, into custody.
এই দুইটা or same হবে না loss আর সেটা 10 and 40 more is almost Parity stairs MA Chaudhary did a counsel for the petition and also Parity stairs DP Goswami did an petition PP on behalf of state respondent. It's an application and section so in connection with so before he is innocent and nothing has been seized from the person representing his petition. He is no way connected in the ATC supply chain. ATC supply chain logistics from where the and from whose vehicle and from the vehicle of the said company, the contraband was recovered. He is the employee of SB Logistics and no way connected in the list offense. However, he got arrested in connection with this case on 15/2/2024, and since then, he is in custody. Charge sheet has already been submitted, but till date, no witnesses could be examined. And charges and for the case is fixed for framing of charge only on 9/4/2025, as one of the accused, Bidhan Roy, was absconding to stop. Further, he submitted that 50/50 service in Mr. Sharma submission eke rakhiba. Yeah, or his submission rakhiba. So your submission will be mainly commercial quantity and these are the materials are there as well.
Materials are there.
They are
Charge yet to be
important
paid.
thing. They are important. Yes, 15. Who is appearing on 15? Sorry, 50 yes, I have noticed too. 50 CRPC notice goes, arrest promo to 9, 50 CRPC notice to 9. Both 50 CRPC notice.
May please your lordship. Apply ground again. Same ground. Same ground. May please your lordship.
Yes, 15. Yes.
Lordship, here lordship, the petitioner is in custody lordship since last 1 year, 2 months and 1 day lordship. 1 year, 2 months, 1 day.
1 year, 2 months.
Months, 1 day. Here lordship, the petitioner was the driver of that truck lordship. Lordship, may kindly come to page number 21, the FIR. I will read only one paragraph, lordship.
Yes.
Page number 21.
Hmm.
At around 12 AM, 10-wheeler, brick red color Ashok Leyland model container bearing number so and so coming from Guwahati to Tripura was arrived at so and so and the truck was stopped by the Naka party at the said place on so and so. The truck was driven by a person namely Ravindra Singh. That is the petitioner lordship. So lordship, the petitioner was the driver of that particular truck which was carrying all the items of the courier service lordship. So my submission would be lordship basically revolves around lordship as because the petitioner was the driver of that truck lordship. Therefore lordship, he was not the contrabands were not lordship in his possession. And lordship, so far as the driver is concerned, lordship, I would like to rely on two judgment lordship. One is Lorikram and another is Gulfamadi lordship. This is the first ground lordship, section 37 of the NDPS Act may not come in the way of the petitioner as because petitioner was the driver. And lordship, I will read only 2 paragraphs of those judgments lordship. Let me kindly come to take up the first judgment lordship, bail application 965 of 2022. Lordship, may kindly come to page number 3. A perusal of the case diary, it revealed that 10 cartons containing so and so were recovered and seized from the truck bearing number so and so, driven by the accused petitioner. The FSL report shows the simple so and so gave a positive test for so and so. It further transfers that the accused petitioner is the driver of the truck, VRL Logistics, and it is his duty to deliver the consignment of various goods loaded by the said company to the consignee as per Salan. After thorough investigation, the investigation officer in his note dated so and so noted that seized cartons bore seal of so and so company and loaded for transportation of the company truck driven by the petitioner for delivery. It has been further noted that narcotic supplier so and so misused the vehicle of so and so to fulfill their malicious intent, which were just carried by the accused driver. This finding of the investigation officer is of course subject to so and so. Therefore, this court is of the opinion that rigors of section 37 of NDPS Act are not attracted in a peculiar backdrop of the facts and circumstances concerning the present accused petitioner. That is my lordship one submission lordship, and another judgment lordship the Gulfam Ali. By relying on this judgment lordship in Gulfam Ali, this honorable court in bail application number 2107 has held the same thing lordship. Here also the petitioner was the driver of a courier service, and lordship bail was granted to the petitioner. And lordship, another judgment of a division bench lordship, I am relying on lordship. For the factual part, lordship, the first paragraph is there, lordship. I am not reading that, lordship. Lordship may kindly come to page number 3, lordship. Page number 3, paragraph number 3. Prima facie from the circumstances in which contraband substance were recovered, it may not be said that such possession of contraband was coupled with the requisite mental element that the petitioners were aware of the fact that the cartons collected for delivery contained contraband substance. No material is forthcoming as to the petitioners had any nexus with so and so, so and so. From the seizure list, it also appears that apart from 3 cartons, there were other goods for delivery. Here also, lordship, the case is same. One so and so, one LED TV, and 1 carton containing wooden furniture were from prima facie. At this stage, it may be ruled out that the petitioners were having any conscious possession of so and so. So, lordship, this is one part of my submission, and another, lordship, I'm taking the other grounds also, lordship. Lordship, may go through the scan copies, lordship, which you called for, lordship.
You have marked this one?
Yes, lordship. Lordship may kindly go through the arrest memo as well as lordship notice issued under section orange color flag.
Orange color?
Yes, lordship. That may be, lordship.
No, these are the orders.
Thereafter, lordship. Item 15, records of item 15, lordship. Scan copy.
15 you have marked, or in this
15.
15 is out of same FIR. I think
Same
same
FIR,
record will
same.
be there.
For
That's
same.
it. No other scan copy is there. Yes, section 50 CRPC.
Yes, lordship.
Your petitioner's name is Ravindra.
Yes, lordship.
Section
Ravindra.
50 CRPC, yes, sir. Arrest memo also.
Arrest memo is also there, lordship. Lordship may kindly have a
Inspection
look.
memo also.
And inspection memo is also there, lordship.
Doesn't. This is the second ground.
Yes, lordship. And on the second ground, lordship, I'm relying on those judgments, lordship, starting from the Kumar. And lordship, so far as the role of the petitioner, lordship, page number 44 of my bail petition, where lordship in the charge sheet, the role played by the petitioner has clearly been mentioned, lordship. Paragraph number 3, lordship, page number 44. The investigation officer clearly said that, lordship, the petitioner was the driver of the courier service. With this two grounds, lordship may kindly allow me to go on bail, lordship, imposing any conditions, lordship.
Yes, to sign.
He's the driver of that vehicle from where the contraband was recovered of 67
Now
cartons.
when he relied on the other, it was seen that the packets or the cartons were sealed, in fact.
Sealed.
Seal was there. In this present case, whether such kind of thing is there or not, we are not in a position, you can say. Whether was there any?
Nothing was.
Huh?
After going to that present case, nothing, going to the LCR also, it was not,
It was not sealed. Then
door was unlocked, that contraband boxes were sealed, also. Seal boxes were there.
it was
But
sealed.
door was unlocked, door was, when the, during the checking, the vehicle door was unlocked. That was after checking that. And the boxes were sealed.
Boxes were sealed, Lordship. Even Lordship in Gulfam Ali's case also, Lordship, the vehicle was unlocked. Lordship.
Heard Mr. M. Ahmed, the learned counsel for the petitioner, and also heard Mr. B.P. Goswami, the learned additional BP, appearing on behalf of state respondent. It's an application, section so and so, in connection with so and so. Scan copy of the case record has already been received. Here is the same. It is submitted by Mr. Ahmed, the learned counsel for the petitioner. The present petitioner is innocent, and he is no way connected in the LS offense. It is the fact that he was the driver of the vehicle when it was intercepted by police, and the contraband was alleged to have been seized from the said truck. But being a driver of the said company, he was only carrying the cartoons wherein the alleged contraband was kept. Contraband was allegedly kept in the said carton. He further submitted that being a driver, he was not in a position of the contraband, and it was his only duty was to transport those cartons, which was loaded in the vehicle. Most of all the curtains were found in the sealed position, though the door was found to be in unlocked position. Further, so considering this ground, it can be held that the section 37 NDPS Act will also not attracted against the present petitioner, and there can be every it can be easily held that the accused is innocent, and he has not committed the said offense, which is required to fulfill the ingredients of section 37 NDPS Act. Next, at the same time, he further submitted that the accused petitioner are behind the bar since last 1 year, 2 months, 1 day, until that the no prosecution witnesses could be examined by the learned special judge, though the charge already framed.
No, Lord, charge is not from here.
9-4 was fixed for.
Lord, is
So
one probably that's
the
from
case is fixed for framing of charge on 9/4/2025. Before the took the ground of non-mentioning of ground of arrest in the petition. No, sorry, in the notice under section 50, arrest memo and inspection of the law. Mr. Mr. No, it took Mr. Goswami, the learned additional PP submitted in this regard. That from the record, it is seen that he was the driver of the vehicle, but it was within his knowledge about the availability of the contraband in those sale packets. He already submitted that cases of commercial quantity, and hence the rigor of section so and so will follow. Our effort submission on Bihan Kumar around 1830. You also relying on Bihan Kumar?
Yes, sir. Yes, sir.
We have a format, in fact, that's why.
Yes, sir. That is why, Lordship, I am not also supplying the copies of the judgments, Lordship.
Okay. To the satisfaction of which court? Same, I think.
Same, Lordship. Same.
Special judge?
Special judge, Lordship, Shribhumi.
Shribhumi. Special judge Shribhumi. Are Baki more observation, all of them, regarding that one. That the cartons of veterans. Otherwise, it will be over there. Regarding the observation of 37 abstraction, this I will give some.
Level 13,
Hmm?
11, 12, and 13.
You are appearing in all three matters?
No,
or-
I'm 11, my lord.
I'm You are 11.
appearing in 13, my lord. Almost same, my lord. Whatever, my lord. Page 10 is the FIR, my lord. Whatever some persons were playing, gambling, my lord, in a room, my lord. They were arrested, my lord. Page 15 is the FIR, my lord. And type copy.
10 or 15? 10, 15.
10 is the type copy, my lord.
Acha.
My lord. And the type copy, my lord. Long FIR, my lord, that is the crux of the story. Oh, now, my lord, 71, 72 days in custody, my lord. And those same grounds of arrest, my lord. 47, 48, my lord.
He also not complied with.
Not compliant, man, and detention, my lord, 71 days, man, in custody, my lord. As per 11 and 13, my lord. Date of arrest same, my lord. And allegation is that they were playing an online gambling, my lord.
11?
11 and 13.
Item 13.
No, no, 11, date of arrest.
Date of arrest is, my lord, 28/1.
In both 11 and 13.
Lordship.
So now in custody for 70.
1 day.
You have not annexed those notice, no?
Notice I have, my lord, certified copies. I have all the certified copies, my lord. Can give you. And it may be in the CD also.
Yeah, it also.
As soon as they are listed, I will notice also. Somewhere else. These are
Is that
certified.
the Xerox?
The original certified copies are also there, man, and it may be in the case diary also, man.
You have 47, you say, no? Birth certificate also you are.
But birth certificate, man, regarding man, children, man.
Your petitioner's name is Debojit.
Deposit, man. That's problem.
And 13 is Provin.
13,
Probin
Probin Modi and my lord,
Iqbal Ahmed.
Iqbal Ahmed.
Then is deposit one.
Who is Iqbal Ahmed?
Iqbal Ahmed one.
My lord.
Your one petitioner is Iqbal Ahmed.
One is Iqbal Ahmed.
And one is Provin Modi.
Probin Pori.
Otherwise, it's a case of 60 days or 90 days offense.
My lord, to ask, my lord, it is 60 days, my lord, because lordship knows, my lord, 2B, my lord, there.
3184 is 90 days.
But
90 days, I think.
2B, my lord, is, my lord, as per go back section, it is 90 days, but if you, my lord, read, my lord.
Lordship, so far the organized crime is concerned, my lord. The condition
90
precedent
days,
is that continuing unlawful activity. As per proviso explanation 2, my lord, Roman 2, means the activity prohibited by the law which is cognizable offense punishable with imprisonment for 3 years or more undertaken by any person either singly or jointly as a member of the organized crime of syndicate or on behalf of such syndicate in respect of which more than one charge sheet have been filed before the competent court within the preceding period of 10 years, and the court has taken cognizance of such offense and includes economic offense. So, my lord, there must be a charge sheet in respect of the offender, my lord. But here in this case, forward is totally silent regarding filing of the any charge sheet against any of the
That's,
persons.
most probably in 10 days back, one judgment was there from the Supreme Court also. Now you are to furnish the every detail if you are in custody. or
Lordship.
In other case, if
Lordship.
any cases again registered against it, not only the duty of the prosecution, it will be duty of the prosecutor also. So to mention if any cases is been pending. So.
No case is
here-
pending, lordship, nothing. And forwarding also silent in this regard, lordship. Otherwise also, my lord, the subsection 2B, in any case be punishable with an imprisonment for a term which shall not be less than 5 years.
but which may extend to imprisonment for life. It is under 2B, my lord. And the non-compliance of 47 and 48 is apparent in the case, my lord.
Otherwise, the allegation was
Other
very
indication is,
serious.
Yes, they are operating a gang lordship, they targeted some consumers and promising to pay some commission. They collected their bank details. And using their bank details,
Hmm.
they fraudulently taken some loan from the other purposes. You see, nexus is going on, lordship, it is doing illegal things for the. Huge amount of money was deposited on their account for free. And these citizens are also taking the commission of that, and someone is doing the main part.
Some other person also behind this.
Behind this. Sufficient materials are there against the application of the 180 is here, actually. Item 12, but he is yet to be arrested. He is the mastermind of this hotel gang.
Lord, we can serve, my lord, 71 days in lordship non-compliance of 47 and 48. lordship. That is the basic element.
Only thing is the lordship, regarding DA lordship, considering rank of detention and the grounds of arrest also lordship. But AB cannot be lordship. Okay, protection of action. At this case.
11 to the or submission of more or less. At that number 11 is Mr. SM Abdullah P is there, and other one is P Das is there, no? 13. 11 to 13. Mr. SM Abdullah P, the learned counsel for the petitioner. Listen application by so and so. Case diary received, it is the same. It is submitted by Mr. Abdullah that the present petitioner is innocent and is not involved in the alleged offense. Further, it is submitted that the present accused petitioner is in custody since last 71 days as he got arrested on 28/01/2025 in connection with this case. So considering their length of detention, their prayer may be released. The prayer may be considered as the IOC was sufficient opportunity to interrogate the present accused petitioner, keeping him in custody. Next paragraph, we further submitted that while arresting the present accused petitioner, the grounds of arrest were not communicated to him, neither in the arrest memo, public inspection memo, nor in the notice issued under section 47 BNS. Next, Mr. Gusami, the learned additional PP, submitted in this regard that there are sufficient incriminating materials against the present accused petitioners and who were engaged in and this is an organized crime who were operating and who were targeting the various consumers all over the India, and they obtained their bank details by promising to deliver some commissions to the targeted consumer, and thus they are involved in a scam of online involved in a scam wherein huge amount of money has been deposited in their account as a commission. Further, he submitted that it is a fact that the grounds of arrest and were not communicated to the present petitioner through while issuing notice, arrest memo, or the inspection memo. But he submitted that considering the incriminating materials against the present petitioners, further custodial interrogation may be required in connection with this case. Considering the length of detention and non-compliance of so and so. It will be to the satisfaction of which
CGM Nova, man.
CGM Nova. Yes, 12.
Obliged.
Obliged.
New business.
Lordship page, FIR page. 12, my lord.
Page 12.
12, my lord. One allegation against the accused person, my lord, and the police red-handed them, my lord, caught red-handed and arrested them, my lord. And only,
Caught red-handed. Caught them red-handed.
Yeah,
The other co-accused.
my lord. And only one of the accused, my lord, that's lordship implicated on the statement, my lord. Nothing else, my lord.
You got this statement also? Where from you are saying?
Yes, by FIR, my lord.
Hmm.
In FIR itself, with due respect, I have the honor to inform you that on 27 January 25 at about 3:55 p.m. input received from Traditional SP Crime Nogav that few persons campaign at House Bubul Ahmed and Dupguri Colony Basti under jurisdiction of the NDPS and engulfed illegal money by committing cybercrime and collected huge amount of money through it. Proper authority has been obtained from the higher authority. Itself, along with OC, PS, and PS staff conducted secret operation at the house of Bubul Ahmed and Dupguri Colony. During operation apprehended below 4 suspected individuals while they were engaged in illicit activities through their smartphones. During spot interrogation, they revealed that they were employed of Tawajul Islam. I am Tawajul Islam, my lord.
You are Tafuzul.
My lord. So-and-so village, so-and-so and so-and-so, and they admitted that they were involved in the online gambling related cyber crime. Specifically, on all computers and everything recovered from their possession, my lord. Only just this one accused tell I am the employee of Tawajul Islam, my lord. Just implicated also.
In the case of Procedural Islam, this petitioner and Bulbul Amin is the main person.
Petitioner is a businessman, my lord. He's running a business, my lord. Supplying the stones and rods and supply building materials, my lord. And he even doesn't know operate the computer, my lord.
He provided the SIM cards and other apps lordship to this petitioner lordship.
SIM card from?
SIM card from other they targeted some persons that collected their SIM cards and used their SIM cards. They're taking some loans and money deposited money on their accounts. Lordship.
Was there any house search for the present petitioner? No.
The house of petition, nothing recovered, my lord.
Nothing recovered.
Nothing recovered from it.
But he was from that day he was absconded from the place of crime.
I will cooperate the man. Could you
But he is
cooperate
fully involved in this. All our settings in his name, lordship. Technical part was done by him, but the technical part was there, where we inserting scheme and apps were downloaded and the name was shown in the Android mobiles. But that technical part was done by him, this petitioner. At least cannot be done there. And this will be able to.
Or Mr. JUMM Lasmus. And also heard Mr. DP Goswami, the learned additional VP, to frame on behalf of said respondent. This is an application, the section so and so in connection with so and so. City receipt, where is this? It is submitted by Mr. Roscoe that the present accused petitioner is innocent and he is no way connected in the alleged offense. He is a businessman by profession and he is not even known to operate the computer or the smartphone, but during the interrogation of the other co-accused persons, the name of the present accused petitioner was uttered by one of the co-accused, and on the basis of which the police is presently searching for him. Nothing was recovered from his position at the time of house search. However, he is ready and willing to cooperate the IO in further investigation of this case if he is right up to ruling such he do record 11 up to 11 but 30 since are willing to appear before the IO and to cooperate in the further investigation of this case, if he is granted with the privilege of pre-arrest bail. Next point, Mr. Goswami, the learned additional BP submitted in this regard that there are sufficient informative materials collected by the IO during the investigation against the present petitioner, and he is the mastermind of the entire organized crime, whereby some people were targeted and the SIM and the other card, etc., were obtained from the said persons, whereby they were committing the cybercrime and collected huge amount of money in the name of those targeted persons. He is the main person, he is the main kingpin who used to, he insert the SIMs, no? He used to, he used to look after the entire technical part and after technical part, after collecting the SIM of various targeted persons and other bank details. Accordingly, Mr. Goswami submitted that his custodial interrogation is very much essential for the purpose of proper investigation of this case, and hence he raised vehement objection, submitted that it is not at all a fit case to grant the privilege of pre-arrest bail to the present accused petitioner. Thanks, Pada. Hearing the submission made by learned counsel for both sides, I have also perused the case diary, and it is seen that the IO has collected sufficient implementing materials against the present accused petitioner, and he is the main kingpin who organized the entire crime and employed the other co-accused persons. Through this online gaming and cyber crime, the present petitioner, along with the co-accused persons, has had targeted various persons, and thus a huge amount of monies are being deposited or transferred to their own accounts. Next, para. In view of this, I find that in view of this, I find that custodial interrogation of the present petitioner may be required for the interest of the investigation and to unearth some other facts of the case, as well as to nab any other culprits if any. In view of this, I find that it is not at all a fit case to extend the privilege of pre-arrest bail to the present accused petitioner, and hence the same stands rejected. The petition stands rejected.
Obliged.
We have not received the case diary. My lord, can you,
We have received the case diary.
not received it. My lord, can be on 10th, my lord, or other, all the co-accused has been granted bail by the court below, my lord.
Not fixing anything.
It's from STF only, my lord.
Huh?
It's
No,
from
no,
STF.
question is not that. I am not fixing.
Hello.
Question will receive, but I won't fix.
Can be on 11 then, my lord.
No, we are not fixing before PO.
Already-
Since when your petitioner is in custody, since when?
Third of March, my lord.
Hmm.
3rd of February, my lord. It's already been 68 days, my lord.
What is the allegation?
Allegation means, my lord, under section UAPA Act, my lord, and arms act is there, my lord.
The city is required then.
68 days, my lord.
These are 90
If
days
possible,
offense,
my
I
lord,
think.
can it be on-
90, it can be extended up
My
to
lord, can it be on
120,
11th,
180.
my lord, kindly, my lord.
Pardon?
Can be on 11th, my lord, the last day,
No, we are not fixing on 11.
my lord.
That's what. Not fixing on 11, 10th, not fixing.
Then can it be on the reopening, my lord, then?
At best, there can be. Or other,
21,
Yes.
my lord, 21st.
or do you have the other, any other ground?
No, my
This regarding that ground is
No,
not
no.
available.
21st.
Demand for a 20. Okay, 21st, on the reopening day. Sitting
Leave
up
the
this-
objection.
Please come to-
Eighty?
May I please, your lordship?
Yes.
Kindly, this matter may take tomorrow, lordship, because lordship, the petitioner, lordship, he was arrested in this case, lordship, he was shown arrested, lordship. And originally he was arrested in another case, lordship, which was fixed on tomorrow, lordship. As item number 4, lordship. So lordship may take along with that matter, lordship.
No, but here you are shown arrest or what? Item number 4, tomorrow's matter.
Lordship, item number 4, lordship.
Okay. List item number, just tell us. Item number,
4, lordship.
sorry, item number, no, case number
Case number, lordship.
1093
1093, lordship.
of 25.
Lord 25. lordship.
Please record along with BA number 1093 of 2025. On Kalikantari, 9. Okay.
DP, lordship.
Twenty?
May it please your lordship. This bail petition relates to NDPS case, my lord. Uh, The item is heroin. My lord, two times it was required from different places. First, my lord, from residence 164 gram, then from other place 112 grams. Only 26 gram excess from the commercial quantity. My lord, the accused in 338 days. For 338 days, he is in custody. My lord,
Otherwise, cases registered under 21C.
sentence.
How many days you say? 300? What is the case of the case? Stage of the case?
Recently, charge has been framed on 5/3/2025. My lord, my ground is, my lord, is speedy trial. My lord, this charge sheet was submitted on 28/9/2024, and charge has been framed only on 5/3/2025. And the commercial quantity is very less, my lord, 26 gram excess from the, and it was not at the end in single occasion. It has been required in different occasions. So does not he is entitled to bail.
11 PWs are there. At this case, some witness may be coming. For some difference. Because charges came very recently, factory. 25.
So you have to see because it's a commercial quantity, otherwise your incremental materials are there. Materials are there on the basis of which most probably charge sheet is also submitted.
It's also failed.
And we see now the prayer for incarceration is also difficult to take, whole opinion at this stage. Because the case is fixed, charges already been fixed and framed, and the case is fixed for most probably evidence. So we, at this stage, we cannot say. There may be a speedy trial also because 2-3 evidences. If where is this pending, by the way?
Margarita.
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 So now the courts are dealing with these materials. I don't know. It may take some. Maybe may take another 6 months or 7 months, but I cannot say at this stage. 338 cannot be a consideration of 338 days. Difficult on our part because it doesn't come under the expectation of the long incarceration also. That is the one aspect. That's why I'm just asking you, is there any other ground? You're saying that no other ground.
No other ground.
Yes, Goswami.
This may be examined after some days, if you know, otherwise. Dispose it of and file a fresh after some time, so it is examined.
What do you want to say? Up to date case record may be called for, it may be fixed for some other day,
My
or
lord,
it can be disposed of.
my lord, keep it pending, my lord, for some other days. I shall take instruction whether in the meantime any other ground is there.
Okay. You are Mr. VK,
KKD.
Huh?
KKD,
KKD.
my lord.
Acha, KKD, heard Mr. KKD, so and so. Scan copy of the case record is received, but at the request made by the learned counsel, Mr. Day, the matter may be listed, let it be on 30 of April, 2025. I mean, 30th of April, 2025. Updated case record be accordingly called for. Ministry will do the needful.
Pretty.
Other side was.
May I please?
Respond number 2, your appeal. Yes.
Lordship may peruse FIR page of 14, Lord.
Page 14.
14.
Yes.
Very true. With due respect, I beg to state that my sister, namely Rita Das, is about 17 years old. In the month of April of this year, one person, namely Bablu Chakraborty, called my younger sister over telephone, threatened her to kill, and forcefully committed rape her in an under construction building near TP Sunrise Escape.
I'm sorry, Lordship, there is an office note, Lordship, probably scan copy has not been received. I'm not wrong. Foxo case, Lordship.
Yes, boxes. Scan copy is not.
There is an office note, Lordship.
Scan copy is still awaited.
Let it be listed.
Scan copy is still awaited. You have to fix another date because scan copy is required. Otherwise, as per your instruction, what is the stage of the case at present?
I have no present days that
No
right
instruction.
now I have no instruction. At the time of filing, no evidence was started. Lordship.
Evidence was not instructed.
Not started. And I have taken that ground also, and another ground I am seeking. I have been filed seeking default bail, Your Honor.
Default bill at this stage.
Lordship.
Why and how?
The
You did not avail the opportunity at the time of 60, 90 days, whatever. And now you are seeking default bill after filing of the charge sheet. Acha.
I can take, Lordship.
So anyway, it's okay. You can take steps or whatever. You. No. All for. Heard Mr. S.H. Sharma, the learned counsel for the petition. And also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. And MS Andeka, the learned counsel appearing for the respondent informant, respondent number 2. From the office note dated 5/4/2025, it is seen that it is scanned copy along with the case diary as called for is not yet received by the registry. Issue reminder, registry is hereby directed to call for the scan copy along with the case, up-to-date scan copy along with the case report, case diary, on or before the next date of listing. It had to be listed, please, 29, 30, 30.
21.
May I please, Your Lordship?
Your affidavit has come.
Yes, it is on record, madam.
Yes.
Kindly see the additional affidavit, madam. Kindly see, I have annexed. What extra particular? Kindly see, I have annexed the grounds and the up-to-date record and the my lord co-accused order, my lord. The two persons were arrested on same footing, my lord. Zabir Ahmed and Ruhul Amin. Zabir Ahmed, my lord, your lordship granted bail. Kindly see the page 54, my affidavit. Kindly see page 54. Here, my lord, I am also entitled on same footing. Here also I have annexed the grounds of arrest, the notice under section 15 and arrest memo, inspection memo. And the up-to-date record, up-to-date status report also I have, my lord, annexed. Last
So as
order,
per the
page,
up to date, any other witnesses examined?
no witness, my lord, kindly see page 75. This is the last order.
$75.
Yes,
Yes.
madam. Order dated 24/2/2025. The next date fixed for evidence on 15/5/2025. This is
And
exactly
till now, how many witnesses
no
are being?
witness examined. This is on 1/4/2025, your lordship's order and co-accused order. This is also reflected in the co-accused order. No witness examined. So after putting the same record, same everything, and I have annexed the up-to-date orders, my lord. So I am entitled, my lord, as per the co-accused bail order. May I submit this ruling, my lord, cited.
Pardon, which are going to submit?
Ashish Kapoor and this is up to date. Otherwise,
Ashish Kakkar is there with us.
then all you have.
এটা খালি same থাকিব order. এটা submission খালি দিব. From your petitioners, was there any recovery?
Both were recovery from both persons, my lord. However, my lord, I am saying the fact of the case is that, my lord, the recovered from one godown at night, my lord. And the godowns, the owner's names of godown was Akabuddin, who was not made as an accused. And I am taking the plea of the non-compliance of section 42 subsection 1 because the godown was searched, but no search warrant was given, no authorization order was given by the superior authority in respect of search of the godown. So it is non-compliance of section 42 subsection 1. This I have, my lord, I have asked before your lordship in co-accused bail hearing, my lord. This is reflected in the co-accused bail hearing. Same plea I have taken, my lord. So both were arrested in same footing.
খালি এটা দিব আশিস কাক্কর to লগাই দিব খালি হ্যাঁ আশিস কাক্কর we have, what was the citation? আশিস কাক্কর, no we have.
Yes.
এটা খালি সব only আশিস কাক্কর number 3 আশিস কাক্কর লগাই দিব. I have the citation with us. So it was under whose satisfaction?
Satisfaction, my lord. This is special just Sribhumi.
Special just review.
Sribhumi.
Special just review. No witnesses examined, all are same. এটা খালি line লগাই দিব, is paid for bail on the, also on the ground of parity. দিব. Co-accused has already been released on bail and Mr. Chaudhary has paid for bail also on the ground of parity. Okay.
Published.
$22.
Maybe legal lordship.
Yes.
Petitioners are behind the bar for last 82 days here. FI is at page number 19 here.
82 days.
82 days here. 90 days is that can be arrested under section 61 to conspiracy 147, wagering war against the state, and 302 317 60 days here. And read with section 17 and 18 UPA and 51 of wildlife here.
Who is appearing in here? You are appearing or other one? Bonk Sharma.
So required for wildlife lordship, otherwise the CD is available. And CD has been run through by DP Goswami lordship. So
So Goswami had seen.
just after a few minutes, lordship, he is here only. After a few minutes.
Okay. Otherwise, Sharma is, Bonkim Sharma is also appearing here. Now it's only the PP is appearing here.
On last that copy was served to Bongim Sharma here. But in wildlife section, 60 days is already over here. Sasi is not like that. Right.
Even then, lordship, I will just inform.
So you are basically, the case is registered under the wildlife section as well as
wildlife section and UPA, unlawful protection. There is
UAP also there. Unlawful activities act is also there.
yes, but there is no such only allegation, Your Honor. As per my information, there is no such materials against the petitioners, Your Honor. Further, the other grounds, Your Honor, as per my information and certified copy of the arrest memo, the ground of arrest is not communicated, Your Honor. There is an arrest memo, this is a certified copy, Your Honor. And other things in the case, there is my PP with Lanet, senior PP, please say whether there is any communication or ground of arrest. I have no.
Yes, case, there is a material against the petitioner. They were sent to jail in this similar offenses.
I am petitioners are shown arrest here. It is true that they were arrested in earlier case in
No,
connecting.
these are only the arrest memo. Where have we annexed the 47?
I have no copy, but learned people from the
Okay,
record.
just see record.
So far, my information, they were not indicated by ground of arrest. They were owners in this case, and earlier they were arrested in Gopur. Yes, case number. I have annexed the original FIR in case number 28 here. Gopur case number 28. In the first week of November, since then they are in the judicial custody.
Here they are shown as shown arrest.
Shown arrest here.
Shown arrest from where? See, they are in custody.
Since 17/1/2025. 82 days here. Number 12 length of detention may be considered. Nothing recovered from them here. Only allegation. In original affair, we got bail here. Begune? Bego, legal bego, legal bego.
Can you please have the order of shown arrest? Where is the order? Have you annexed this?
Yes. PR for solar.
Yes, prayer for shown arrest and order.
PR for solar is page number 23.
This is for the prayer for shown arrest.
Okay.
And the order was passed on 2002. 2002.
This is rejection order.
This is the rejection order.
Rejection. On the same day that they were.
No, where the prayer for shown arrest was allowed. Is there any order?
PR for issuing production one on 21. They have paid on 21. 21 case number 20. PR for production warrant.
No, prayer for production warrant and after perusal of the case, the order has to be there for their prayer for shown arrest, most probably allowed. That's what I'm asking.
I'm not.
You have not annexed this one.
I'm just annexing the PR for shown arrest. As per the PR for shown arrest.
So we have not annexed the order of shown arrest.
Yeah, only arrest memo is there. Against the both petition of
Yesterday you took one dictation for
it.
S as the
Need to come to paper.
prayer for shown arrest was discussed. Today we also take this one and whatever. One more matter is there in item number, most probably it was 3. Item number 3. It was from the same. It's cause of case. Preliminary part, if anything is there, I'll place it. For item number 3 and item number 8, both are for the same accused. 8 I have already dictated to Sharmila, and 3 is kept because of shown arrest. Yes, Gusami.
Yes, otherwise sufficient materials are there. They even went to there on in the year 19 lordship. 2019 lordship and first around 6 months ago lordship. They are another idea was they have another idea of lordship. The gang is operating lordship. Several persons were involved.
The main person is from Naga Kuki Naga. Yes. Articles are provided by, weapons are provided by that person also. After completion of the offense, that person bought the horn lordship 30 to 40 lakhs, paying 30 to 40 lakhs to the
Paying
30 to 40 lakhs
whom?
paid to them lordship by that Naga person lordship. He's the main accused person who provided them weapons to kill the post the rhinos. The 7 to 8% are there lordship, along with these petitioners lordship. With the help of these petitioners, they came to Kaziranga and committed the offense lordship. That's why I'm sick for annexing this.
Arms were provided to them,
Yes,
or they provided to
No,
arms to
they-
Naga person.
I'm sure provided by that Naga person to them lordship. With the help of some other villagers, other persons lordship, they killed that rhino with their arms and ammunition.
May I pray? All such allegations, nothing recovered from me killed area.
Just tell us the allegations of pardon.
Koikus are also sitting there and lordship. They are helping to kill the rhinos. And they also stated the same thing before the IO lordship.
Now that is known, but the question is that the apart from the wildlife sections which are being attracted, as you have submitted that they were supplied with arms and all from by one Naga person for poaching the rhino things. Now the question is that apart from it, is there any allegation which connects them with the UAP Act also? Is there any?
That part is UAP part lordship, that is not reflected in the case records. UAP part. Even again.
In FI, there is a mention
Yeah, fine.
of no, not for prayer for shown arrest.
In the FIR,
Based extremist group
No, in
who
the
are
FIR,
involved in several terrorist activities and raising fund for to illegal poaching activities. So through this illegal poaching of the rhino, you are collecting the money also, raising fund
these are allegations.
for the extremist activities or
This
organizations.
is not true.
one of the accused is stating such type of thing lordship. Please, if lordship, allow me to read this statement of some part of the statement also. তাৰপিছত এদিন পিছ ৰাতি বুঢ়াপাৰা অকমান নেশ্যনেল হাইৱে ক্ৰছ কৰি পাই 300 মিটাৰমান দূৰত এটা গড় পানীত অহা দেখা পাই উক্ত গড়টো গুলি মাৰিছে। ষ্টেটমেণ্ট অফ দ্য নাগা পাৰ্চন লৰ্ডশ্বিপ। গড়টো গুলি মাৰোতে গুলি শব্দ শুনি ফৰেষ্ট লোকে হাল্লা কৰি অহা শুনাব যেতিয়া আমি তিনিজনে নেশ্যনেল হাইৱে ক্ৰছ কৰি নোৱাৰি কাজিৰঙাৰ ভিতৰৰ ফালে পানীয়ে খোজকাঢ়ি যাওঁ। তাতে দিনটো থাকি সন্ধিয়া 6-7 বজাত পুনৰ খোজকাঢ়ি হাইৱে ওচৰত পাওঁতে ফৰেষ্ট লোকে আমাক গুলি মাৰি পুনৰ জংঘললৈ সোমাই গৈ ৰাতি তাতে থাকি পিছদিনা দিনত জংঘলৰ ৰাস্তাত বেক কৰি ৰাতি হাইৱে পাৰ হৈ বুঢ়াপাৰা পাইছিলোঁ। And Parity lordship, they made a camp on that Kaziranga, inside the Kaziranga jungle lordship. Against this person, Lordship, only posting of rhino, Lordship. In your organized Lordship. That Naga person provided them to the weapons and with the help of that Lordship, they poached up rhinos and supplied to them, Lordship.
My lord, considering the length of detention and the other ground of not communication of the ground of arrest, then we consider your honor, length of detention. Then 82 days, there is no possible detention for further interrogation. And they are, since first week of November, they are in the judicial custody, your honor. We will face the trial, your honor. We will cooperate with the investigation agency and before the trial, your honor.
Mr. Sharma, any other assumption from your side?
My lord, we have not made a party, my lord, and my lord, though my lord, the plea was
Copy was
served
served
on
to
me, my
you.
lord, but formally, my lord, party, wildlife is not a party, my lord, yeah. So, my lord, that is why, my lord, I have some difficulty to submit on that part. Otherwise, my lord, it is a clear case of, my lord, wildlife section, my lord, 51 attracts, my lord, because it is a clear case of, my lord, rhino poaching, and it is a organized way, my lord, and they are a habitual offender, my lord. Because, my lord, earlier also, my lord, there is some instances that they are engaged in that, my lord, illegal poaching.
So now they are on the length of detention, both length of detention and arrest procedure. These two grounds.
81 days, excluding today.
Otherwise, my lord, the amendment, Assam amendment, my lord, it is a 90 days offense.
90 days, yes. That's what I'm
submitting 90 days.
Very good. You're Mr. Nell
Opinion.
and Mr. Peniel, the learned counsel for this petition, and also heard Mr. DP Kusami, the learned additional DP, appearing on behalf of state respondent. There was an application under section so and so in connection as well as. Is submitted by Mr. Neo that they present the accused petitioners are behind the bar since last 82 days in connection with this case. With as they were shown arrest on the prayer made by the IO. However, they are in custody since last first week of November in connection with the other case, and the 82 days behind the bar in connection with the present case where they were shown arrest. Further, Mr. Neum submitted that there is no ingredients to fulfill the section 17/18 of EA bracket of P Act, and there is no averment in the FIR that they were running any organized crime. However, considering the length of detention already undergone by the accused petitioners, their prayer may be considered. And prayer may be considered. Mr. First Expert, Mr. Neil further submitted that at the time of shown arrest of the present petitioners, no grounds of arrest were communicated to the present accused petitioners in the arrest memo which were issued to them. And in the same time, we submitted that no notice under section 47 or 48 BNSS was issued to the present petitioners informing about the grounds of arrest as well as informing their friends or relatives for the arrest in connection with this case. Which is so and so. If I do Mr. Goswami, the learned additional PP submitted in this regard that the present accused petitioners are the habitual offender and they were They are also connected with 2, 3 other matters in the for committing similar kind of offense of illegal poaching of rhino. Mr. Goswami further submitted that from the materials available in the case diary, it is seen that one Naga person used to provide the arms to the present accused petitioners for taking 30 to 40 lakhs, taking 40 to 40 lakhs, and these petitioners are engaged in illegal rhino poaching and illegal rhino poaching. Full stop. The IO has collected sufficient materials against the present petitioners who were involved in the poaching, and accordingly, Mr. Goswami raised objection and submitted that it is not a fit case to grant bail to the present accused petitioner at this stage.
Yes. Next item, 21B is the offense, 51 days in the custody. Madam, list shows that diary is not there. My lord, my learned friend may kindly be asked to receive instruction other charge sheet is submitted.
You can take
Charge sheet
instruction.
not sub, I have taken an instruction. CS
Then-
not taken.
No, charge sheet not submitted, but whether there is a probability of submitting charge sheet within 8, 9 days, that on charge also you can.
Charge sheet. Huh.
Unless.